All right, with us now is former Manhattan prosecutor Jeremy Saland. Jeremy, Donald Trump says he wants a new judge. Is this like a kid saying, I want a pony, or is there legal basis to this? Is this real?
None of it's like a pony. It's maybe holding your breath and stomping your feet. He has to make the argument, no doubt about it. But the issue is not whether or not the judge is impartial or not. I mean, ultimately it is, but it's whether there's a reasonable perception that he or she might be impartial. So it's not just might be impartial or seems impartial. There has to be a reasonable standard here, not just what you want to say on social media in big bold letters that the judge is bad, the judge is biased. There has to be a factual basis.
Okay. In those statements that were made that are cited in the filing, does that rise to the level?
Well, from someone who may not be aware, and that's a fair thing to think, well, it sounds pretty bad, but it's also said in the context of that proceeding. And when it's in the context of the proceeding, the courts generally say that is okay. We're not talking about something ex parte. We're not talking about something that maybe the judge will benefit from. This is a part of a proceeding, which is reasonable.
And by the way, we've heard some of that language before in other cases, like with the Oath Keepers, where the judge did mention that, there was fealty somewhere else. It wasn't necessarily to the American democratic way.
It wasn't on an island. These are all sort of tied together, too.
Right.
Who makes the call? You said that it has to do with the perception, not, there has to be a set of facts. Who makes the call?
It's a difficult thing to do because you're asking the judge you're before to say, hey, judge, I don't think you're fair, but don't take it out on me or my client later on. But that's who makes that decision, and obviously, the judge makes the decision. But is
that a source of appeal? Is that like laying? I don't know.
Well, not necessarily right out of the gate. There are means to challenge these things, but the judge is going to rule, and she's going to rule quickly and move this thing forward. It's not going to get stuck.
I was going to ask about that because is this part of the Trump team filing everything they can as often as they can? Can these filings slow things down, or will Judge Chutkan just take this so quickly that it won't get in the way of the March trial date?
So collectively they can. This is going to be, I think, fairly efficient in moving forward. There's no reason to get stuck here. It's going to need to process it and go. This is not something that's going to take a long time.
Donald Trump is also asking for his case to be dismissed. I mean, isn't he doing what defendants do?
In Georgia.
This is in Georgia, in a different case. But isn't he just doing what a defendant would do? I mean, I think just about every case I've ever seen, there is a motion to dismiss, just to hope that it might be dismissed.
Absolutely, and I think it's important for people to understand you're not challenging the facts in that motion to dismiss. That's for a judge or a jury to decide later. You're saying, even assuming the facts are true, does that legally satisfy and sufficiently uphold the law? It's not whether it's true or not, it's assuming it's true, is it legally sufficient?
Right. And in this case, he's saying that the law is that he's basically using an argument that Kenneth Chesborough used when he was trying to get the case thrown out, which is saying, fake electors here, anything having to do with electors is federal law, so you can't charge me in a state court anyway. The federal law supersedes this. Throw out the case entirely. Any merit to that? And what about the fact that Mark Meadows did not have his case removed to federal court? Does that instruct us at all about the law here?
So you're throwing different things and different issues,
John.
So you're giving me multiple questions here in our time frame.
But make it perfect.
But I'll try my best to make it perfect. And the answer is, some of this is beyond the scope of this court, meaning there are arguments that are not going to hold water. They're not going to be sustained. You have to make these arguments because every reasonable argument you can make, you need to make, because you could lose that opportunity to argue it later, and then you lose that opportunity potentially on appeal. So he's going to make those arguments. Mark Meadows is a totally different animal, and merely because that case is not being removed does not mean that it can't be dismissed in a state court. They're two different animals. Certainly there's a nexus, but they're two separate issues. So I wouldn't conflate them, even if there was a relation.
That's a good point.
The only reason I was conflating them, to use aggressive words here, is the idea that it's state law, not federal law. The idea is that the state law is what pertains, is what matters here. There has been a ruling now about where this should all happen. So in a way, does that color the idea that, the electors is a federal issue, not a state issue?
Not necessarily. It can be a state issue too. Remember, even if it was removed to federal court, even if Meadows was successful, it would still be the underlying state criminal code. It doesn't change the federal code.
Jeremy Saland, thank you very much for being here.
Saland,
an education.
Do not mess with the prosecutor.
Never.
I think we should keep our day jobs. I think it's really important today. Great, Stu. Thank you so much. And thank you.